So first, we turn to Section 216 of the Insolvency Act 1986. Section 216 restricts directors from being a director or concerned in the management of companies and businesses with a prohibited name for a period of 5 years from the liquidation of the old company. So a couple of points to note on that. The first is that we are talking about directors in respect of the old company. Please note in this respect that it includes registered directors, i.e. directors registered at Companies House. It also includes shadow directors. A shadow director is someone behind the scenes upon whose instructions the Directors Act, that's Section 151 of the Insolvency Act 1986. It also includes de facto directors. That's someone who isn't registered as a director, but is in fact acting as a director within a company. It's worth noting that as well as restricting from the directorship, it also restricts from the management of the new company. So although you've got to be a director of the old company, in respect of the new company, the restrictions are far wider because it also includes management. I finally want to just touch on some very brief points in relation to Section 234 to 236. First thing I want to mention is the case of Primeo Fund, which is a 2016 case. That was a cross-border case, but it provides a really useful summary judgment as to what the position is in the judgment. It basically makes clear that reasonable requests are perfectly all right for liquidators entitled to bring them and will get his costs, so long as they're not oppressive. And it's high burden to show that they're oppressive. Examples of what might be oppressive is when you're asking for information stroke documentation, which is completely irrelevant. But remember this, it would be rare for an insolvency officer to be asking for that information if it's not relevant or potentially relevant. Also, another example might be that the documentation being asked for is ridiculous, it's overburdensome. But again, bear in mind it's a very high threshold, so be careful before you fight it on this point. The one point to bear in mind is if litigation has been commenced, then as per the case of Atlantic Computers, which is a 1998 case, there must not be an unfair advantage for the office holder. So what he can't do, for instance, is use Section 236 to interview all the witnesses to get an idea of what they're going to say when he's in the middle of litigation.